Yes, even now. Yes, we
What
have
is
some.
it? What remains?
It's just this matter is fixed for hearing, Your Lordship. Our seniors wanted to do it, but then my senior is on legs in courtroom number 2.
2018 matter. On premier by the respondent, not objected to by petitioner. This is matter to 1 week.
Oblige, Your Lordship.
Excuse me.
May please, Lordship. Lordship, I beg to mention for an unlisted matter, Lordship. It's a bail extension application, Lordship.
Bail extension?
Yes, Lordship. Interim bail granted. Yes, Lordship.
For the treatment?
Yes, Lordship.
But why unlisted?
Lordship, because the date is expiring on 30th. We had filed day before yesterday. And in fact, my lord, today it was supposed to be listed, but has not been listed, my lord, for that reason, my lord. And tomorrow
you could have pursued the matter with the registry.
Lordship?
You could have pursued the matter with the registry.
We had, my lord, maybe they had some confusions whether it should be listed before the Honorable Court or before Justice Bhattacharjee, my lord. So
why?
We have confirmed it was filed under 482, read with 439, my lord. So that for that reason they had some confusion, Lordship.
42.
482 read with 439, my lord.
This matter may come up tomorrow, my lord, by Monday also, because tomorrow is holiday, my lord. Monday.
I thought you. I'm always there if you're ready. But this the date has expired.
It is supposed to, no, not today, my lord. It is due to be expired on Sunday, my lord. Sunday.
First you said 30th, now you said
no, my lord. I'm sorry, my lord. It's on 5th, on Sunday, my lord. Not it expired, my lord.
In that case, my lord, we can take up at the bottom of the list, my lord.
Oblige, Lordship.
Supplement cross list, item number 1.
This is a
this is the second bail application before this Honorable Court, Lordship. While rejecting the earlier bail application, my lord has given liberty to the accused. That is at page 13, Lordship. Para 10, Lordship, and 11, Lordship. May I read, Lordship?
Yes.
At this juncture, this court is not inclined to allow the prayer made. Petition is hereby dismissed. Before parting, this court would request the trial court to expedite the trial of the case, and if at the end of 3 months evidence has not been laid, the accused person is at liberty to approach this Honorable Court for a fresh look on any prayer made for grant of bail. In view of the above, this petition could dismiss and stand disposed of. What happened, Lordship? That next page, Lordship, on 5th October 2023, then examination of chief for one witness was late, Lordship, and the cross-examination was reserved, Lordship. Then the matter was proceeded again on 1910. Thereafter on 1st of November, Lordship, then cross-examination was not done, Lordship. That means it has already been 3 months, Lordship.
Yes, see, the fact remains that at the relevant time when this court has passed the order, evidence has not yet been read.
No.
Eventually it was.
Yes.
How many witnesses have been examined?
Not yet examined, Lordship. Only the examination in chief or only one witnesses, Lordship. That cross is reserved for.
Anyway, that process has
started. My Lord, apart from that, Lordship.
What is the offence?
21B, Lordship. That is intermediate quantity, Lordship.
Intermediate,
Lordship. It has been more than 1 year, Lordship, and moreover, she is suffering from some ailment, Lordship. And twice she collapsed in the hospital, and subsequently she was admitted to the Nongpo hospital, Lordship. So apart from that, I am raising that grounds on Lordship. I am ready to cooperate, Lordship. It has been more than 1 year, Lordship. Let record may be called for 1 week, Lordship. Later on, my Lord can. Moreover, she is a lady, Lordship.
Yes, Mr. Harwala, what is the allegation against the
Lordship, the allegations which the submissions made by my little friend that he is unwell is not
No,
provided in this.
How was he involved with the alleged offence?
Lordship,
How was he involved with the alleged offence?
Lordship, that I have to look into the case diary. Lordship, there's not much which is provided in here.
You have the case diary with you?
Lordship,
You don't have the case diary with you?
no Lordship. Lordship, this is for motion as of today, Lordship.
The late record may be called in for appreciation.
Heard Mr. Session, letter counsel for the petitioner. Only the state is the respondent?
Yes, Lordship. Only this step, Lordship.
Lordship, what is state? That page number 4.
State respondent is represented by Mr. H. Harolang Leonard, additional senior GE. Before proceeding with this matter, the learned counsels have submitted that the case diary may be record.
Lordship, charge sheet, sorry, been filled. Lordship. My apologies.
So will that the records would include the charge sheet, because now it's already proceeding in court.
Lordship,
But this court will not call for the court record.
Lordship.
Room to go. Records of the case containing the charge sheet is required to be produced so as to appreciate the issue raised in this petition. Although the matter is proceeding before the trial court with the evidence of with the evidence of one witness being recorded, in the process of being recorded, the learned counsel for the petitioner, referring to the order passed by this court in
20 application 20 of 23, Lordship, page number 11.
BA number 20 of 2023, dated 25/7/2023, has submitted that this court has allowed for a fresh look on the prayer for grant of bail to be preferred by the petitioner, which is hereby done so. In view of the submission made, the prosecution is directed to file the relevant records or parts of the record for perusal by this court as prayed for. This matter on 9th, where case is from which
Nongpo.
It's
River district. River district.
9th will be okay.
Lordship.
This is matter on 9th.
Lordship, Lordship, there are two charge sheets, Lordship. One's one charge sheet and the supplementary charge sheet, Lordship.
Whatever.
Subsequently, both have been.
Supplementary would be only on the FSL report.
FSL report, Lordship.
Fine.
Highly obliged.
Item number 2.
May it please, Your Lordship. Also, this is the second round of litigation, my Lord. Lordship, may kindly come straight away to page 84, Lordship.
What is this matter about, Mr. Dev?
Lordship, this is regarding a recruitment process in the transport department, Lordship. If Lordship comes to page 84, my Lord, which was the earlier round of litigation, page 84 and actually 11, my Lord, this was the order passed by Your Lordships on 21st of August 2023, my Lord, whereby I was directed to submit a fresh representation so as to clear out, so that they can reply and clear out the picture. Why, my lord? Because it was our case that our recruitment process was on a different standing, but that has been unnecessarily kept pending. Whereas it was there was some confusion, my lord, as to whether this same issue is also pending before this honorable court as well as in the Supreme Court. So in that view of the matter, my lord, we had filed a representation, and lordships was pleased to direct the respondents to clarify the story, my lord. Accordingly, lordship, we have filed a representation, and in pursuance, my lord, lordship will kindly come to page 97, my lordship, which is annexure 14. The last page, lordship, page 97.
Yes.
Lordship will kindly see, this is a letter of 28th of August 2023, addressed from the Commissioner of Transport to the Secretary of MPSC. If I may just read the content, lordship, very quick. With reference to the letter on the subject cited above, I am to clarify that 4 posts of enforcement checker advertised by the Commission wide number so and so dated 26/4/2017 falls under the 67% direct recruitment reservation and will not attract violation of the pending court case, as the vacancies are to be filled up by direct recruitment at the 33% reserved for promotion from amongst graduate assistant enforcement inspectors are still available over and above these 4 posts. So, lordship, our recruitment process was in connection with this advertisement of 26th April, and there seems to be some sort of clarification from the department, my lord, that the pending court case is with regard to the promotional posts, and this advertisement was regard to the 67% direct recruitment. So it is a separate tranche of recruitment, lordship. However, lordship, till date the results have unfortunately not been declared. If I may pray, my lord, notices may be issued, and the other matter which is pending is coming up on 16th of November, lordship. It can be heard together.
467 is
Yes, Mr. Sulai.
That is on 16th, no?
Amit, please, your lordship. Lordship, let me have the instruction, your lordship, because what happened, if lordship kindly come to page 97 annexure 14.
Yes.
If lordship kindly come from the bottom, second line from the bottom.
Yes.
It appears, your lordship, that the Commissioner of Transport Meghalaya has directed the MPSC for a cancel the advertisement dated 14/12/2020 had been cancelled. Lordship, if I'm not mistaken, this also is this advertisement is also in one of the red petition in
466.
in 46. Most only in 465 of 2021, your lordship. Let me have instruction in the matter.
It's probably coming on 16th of November.
Let it come on 16, your lordship.
You issued notice upon the MPSC.
Lordship, no, it's for coming for the first time. Notices may be issued.
You could have done that before that. But Mr. Dev, learned counsel for the petitioner.
I think this is the advertisement. Second advertisement of 465.
State respondent number 1 is represented by Mr. Indishwar Leonard AAG, and as such, no notice is required to be issued upon the said respondent. The learned counsel for the petitioner has, however, submitted that notice may be allowed to be issued upon the respondent number 2. We allow. Let the said notice be issued, returnable within 2 weeks. List the matter thereafter.
On 16, your lordship. Those 2 writ petitions will come on 16, your lordship.
Then, you see, even if it comes on any, the respondent 2 will have to appear. Then he may seek instruction or he may be instructed. But if you want to, if you can do it, so list this matter on 16.
16. Oblige, your lordship.
Much obliged.
Question number 3.
Chief, here I was directed.
Your Lordship, in this case, I got the instruction to appear in this case.
Have you filed your power?
So I will file my affidavit, Your Lordship.
What is this matter about, Mr. Nobri?
Lordship, this is that superseding matter whereby the petitioners have been superseded by the juniors on implementation of the orders passed by this court in the other matters. Those 89 petitioners. The Lordship has granted them 6 weeks' time to comply with the order. Now it's been over 7-8 months. So that's why I'm before your Lordship.
So, Your Lordship, this matters after judgment was passed, and thereafter, Your Lordship, this matter has been taken up with the ministry, as per my instruction. Because of, Your Lordship, as per recruitment rule, there was an apparent mistake because the order of this Honorable High Court and subsequently Supreme Court went, and some petitioner was given the benefit. And according to this, even this court observed that some junior was given some benefit, but they are not given. And as per recruitment rule, our position was they are so tight that we cannot give as per recruitment rule. So due to this, Your Lordship, as because some junior has already given some benefit, how we can extend the benefit to this? And in this matter, ministry's approval was required. So already matter is taken with the ministry.
Mr. Devnath, you know very well. An order is passed by a court. If you are not satisfied with the order, then you go on appeal.
No,
that's number one. Number two is you have to comply with the order as it is.
No,
you cannot interpret the order in
we are
any
not,
way wish.
no,
you wish.
Your Lordship, we are not going to interpret. We are just asking from the, because financial and other matters involving these matters, and ministry's concurrence is required. Otherwise, it will be difficult. So instead of going for this appeal, Your Lordship, as because some petitioners here, and there is twofold. And another case, Your Lordship, though has not been even superseded or any benefits given. So this could has taken the view in different angle. So in this point of the view of the matters, Your Lordship, the departments thought because of some people, and they are the representation here, when they are not in a position to take the responsibility of the higher position, as because as per recruitment returns not possible. So due to this, you will see, as per order of this Honorable Court, the matter is referred to the ministry for consideration, so that order may be implemented.
You get instructions. If it can be, if it can be resolved, you do it. Or you come up with some explanation or the other.
No, you will see in this matters already, as per my instruction which has come up, I will be filing my affidavit. Already department is taken with the ministry.
Taken with the ministry, no doubt. But as Mr. Nombri has said, see, more than 6 weeks have passed.
There's no compliance.
So you will see,
and the Lordship cannot argue on merits now.
No,
the merit part is over.
You will see, we are not going to make submission as this. We are not going to implement or not having intention to implement. But we are taking the process, and in the process it is there.
That is why I am saying you should come with an explanation as to why you have not been able to do so.
So we'll file the affidavit.
If your explanation is found to be, acceptable, fine. Because you see, as far as contempt matters are concerned, it would be better to be resolved at, at a certain level.
Resolve means they have to comply.
Rather than it coming up, before the court.
No, you listen, even in this case.
Comply or whatever the case may be, as long as you satisfy the petitioners.
No, you listen, we have thought of it. That's what the court has passed the order. It is justified. We have thought about it, and due to this, we didn't went for appeal. So we didn't go for appeal against this case. So rather, we have taken the matter with the ministry, said how we can resolve it.
It's under consideration, like what he submitted is under consideration before the ministry.
You see, Mr. Nobri, we have to understand. It involves.
I totally understand. As long as it's implemented.
And how many of you are there?
In this case, we are 191.
191. So nicely.
And moreover, this position of this warrant of vision has to be created also. This will be the one aspect.
Whatever the case may be.
So due to this, without contact with the ministry, it will be difficult. So we have given that this is the matters, and this could be.
You do one thing, Mr. Deva. Yes. Get instruction, or you advise them accordingly to do it.
It is already processed.
Or at you see, at most they can come with a timeline.
Yes.
That would also be acceptable.
The Illusive already this matter taken up, so I'll file in the.
Wait. Mr. Are you appearing as CGC?
Yes, Illusive.
Mr. R. Devnath, then CGC has submitted that he is entering appearance on behalf of the respondents
1 and 2.
1 and 2, and has submitted that he may be allowed to file appropriate affidavit on instruction being received. It is prayed that this matter may be posted to the next date, for which how many weeks?
3 weeks, Illusive.
3 weeks is sought for. Pray aloud. Place this matter after 2 weeks.
Obliged.
Item number 3.
My lord, this is a service matter, my lord, where the petitioner was working as a librarian in Tura Polytechnic, my lord. My lord will come to page number 3 of the writ petition, my lord.
Termination.
Yes. Now, my lord, what has happened is in the year 2011, my lord, there was an advertisement dated 28/9/2011 under Regulation 3F of the Meghalaya Public Service Commission, Limitation and Functions Rules Regulations 1972, and that is at page number Annexure 1, page number 14, my lord.
Each
Page number 14.
page 41.
Page number 14, 1/4.
Oh, 1/4.
Yes, my lord. First annexure, my lord.
Yes.
Now here, if my lord will see the next page, that is page number 15, at the top,
Yes.
serial number 9, one post of librarian in Tura Polytechnic, Tura. So this was the post, my lord, which was advertised under Regulation 3F, my lord. Thereafter, my lord, the petitioner was given appointment, that is at page number 16, page number, my lord, 18.
Even for appointment under 3F,
Yes,
you have to go through the process of a interview
interview, my lord.
or written test or whatever.
Right. It is the same process which
Same
has to be
process,
followed.
same
Yes.
process. Except that the appointment is
Right.
nature of appointment is otherwise.
Yeah. Yes, my lord. That is at page number 18. 28th March 2012.
Yes.
Thereafter, my lord, she has been again reappointed on 3rd January 2013. That is the next page, my lord, page number 19.
Appointed on
20th March 2012. And thereafter, at page number 19, she was again reappointed.
yes.
Then, my lord, again the next page, that is page number 20, that is extension, my lord. And
Yes.
and as such, my lord, the petitioner, she continued in her service for the last more than 9 years, my lord. And when she was in service, she approached this honorable court. Wide WPC number, my lord, 176 of 2021. She approached this honorable High Court stating that her service may be regularized. But what has happened is, during the pendency of the trade petition, my lord, WPC 176 of 2021, her service was terminated, my lord. And that is at page number, that is at the last page, my lord, page number 42, my lord. 14 July 2021.
Yes.
And very interestingly, my lord, the order of her termination was issued by the principal, which is totally without any authority, my lord, because her appointment was by the government and she could not have been terminated by the principal. Even principal also has been appointed by the government. So he is not the rightful authority to terminate her service. And therefore, this order of termination is illegal, and also for reason that there was no show cause notice which was given to her before passing this order.
Is it required?
Yes, my lord.
Because your appointment is on ad hoc basis.
Now, it may be, my lord, but when the matter was pending before the honorable court, when she approached before this court, matter is sub judice pending before this court, right? And then what happens is, her service gets terminated by a person who is not even authorized to terminate her service. He is not the appointing authority.
Now, what about the court? Have you brought that to the notice of the court?
Now, my lord, what has happened is, when her matter was her service was already terminated, now that termination letter has to be challenged, and therefore that.
No, you see, that could be challenged. You could have filed, you see, either amend your plain, amend your written your petition, or file an additional affidavit to bring this on record.
Yes.
And the court will pass this order.
Yeah, that was of course
Could have done that.
brought into the knowledge,
No,
but this.
And was that matter disposed of?
My lord, he has withdrawn the case.
That matter was withdrawn because it was closed, my lord. The order is there, my lord, at page 41. It says, my lord, counsel for the petitioner submits that during pendency of the petition, some development have happened for which he seeks to withdraw the same and to file afresh. The prayers so prayed is granted and the matter stands closed on withdrawal and accordingly disposed of. And this was because even the court was of considered view, because the termination order has come and that order needed to be challenged.
Nothing is said.
Yes, of course it is not in the order, but that was the background under which this previous petition was closed, my lord. And
those are technicalities which could be
yes, it could have been addressed in that petition itself, my lord. Now, the first ground, my lord, why I am challenging this termination order is wrong, is because the order has been passed by a person without any authority. He is not the appointing authority who can terminate his service.
Can we continue?
My lord.
May I please, your lordship, in that event, let the matter come up on Monday?
Why? You want to go home? We have the whole day with us.
It will not take much time, my lord.
What is the difficulty?
All right.
No, what is the difficulty?
No, it's all right, your lordship. I'll be here. But I must leave by 1.
No,
Only this difficulty, your lordship. I have some prior appointment.
Because you have to leave by 1, so the court has to.
No, your lordship, I'll be here.
Enough time.
Yes, enough time is there. 11:20. Much obliged, your lordship.
We'll see how it proceeds. Then
Only thing is that your lordship, she is overaged. That is the thing.
we'll look at your reply, and
Yes,
then
your lordship.
if you wish to reply on the next date, we'll
It's
let Mr. Sinkon finishes.
Yes, your lordship.
Obliged.
Daily costless item number 1.
Wait, please, Your Worship.
Just a moment. Yes, Mr. Kumar, tell me.
Yes, Your Worship. Kindly see the order of the Honorable Supreme Court, because this case has been remanded back to the Honorable High Court pursuant to the order passed by the Honorable Supreme
No,
Court.
look at the last order. What is this?
I have seen, Lord. That's why I
Who is
want
appearing for
to
the
point out.
petitioner? Mr. Majumdar.
But the last order shows.
Yes, Mr. Kumar is submitting. You should have started, but he has started. Please continue.
I'm sorry, Lord. Page 29, you will also see the order of the Honorable Supreme Court of writ petition number 281, Lord.
Just a moment.
Sorry, writ petition order is at 49, Lord, of 281.
Yes.
Petition number 281 of 202 at page 49.
Yes.
Lordship will see feeling agreed paragraph 1 and dissatisfied with the impugned judgment and order of 1/11/2018 passed by High Court of Meghalaya at Shillong in writ petition number 281 of 2017 and 360 of 2017, by which Division Bench of the High Court, while allowing the said writ petition, has issued the following direction: the state of Meghalaya preferred legislature. And following the impugned directions, your lordship may skip the direction part. That, and then your lordship will see paragraph 3, prayer is quoted by the Honorable Supreme Court. After discussing the entire issue, my lord, if your lordship will come to page 54, paragraph 9. Paragraph 8, my lord, kindly see for paragraph 8. Or 7, 8, 9, I should read all for clarity. From the impugned judgment order passed by the High Court, there is no clarity as to which provision of 1969 Act and the regulation, if any, made thereunder or under Provident Fund scheme adopted by State of Meghalaya have not been implemented. Allegations are two-way. From the impugned judgment and order passed by the High Court, nothing can be culled out as to which part of Meghalaya Act of 1969.
What is this? What is this Meghalaya Act 1969?
This is the act governing the pension benefits to aided colleges. This is the act which is, I will place that, my lord. It will be clear on later part, my lord. And even Assam Act are not implemented. To what extent they are not implemented? Only they are vague government allegations. The High Court also has given specific findings as to which part of the Act 1969 and regulation, if any, framed thereunder are not implemented or complied with by the state before issuing writ of mandamus. Learned Counsel, lordship may kindly mark these lines. Of the original writ petition has also conceded that writ petition before the High Court and grievance on behalf of the original writ petition be confined to non-implementation of provisions of Assam Act 1969 adopted by State of Meghalaya by enacting Meghalaya Act 1969. It does not press for any other relief, including implementation of contributory fund scheme incorporated under the Assam Act. So only relief which has been placed before the Honorable Supreme Court and before this Honorable Court is non-implementation of 1969 Act. The Lordship may see further. In view of the above, there is no clarity at all or a specific finding given by the High Court to what extent the Provident Fund scheme framed under Meghalaya Act has not been followed or implemented. We have no other alternative but to remand the matter to the High Court to consider the writ afresh with respect to the allegation of non-implementation of Provident Fund scheme framed under Meghalaya Act 1969. As observed here, all other direction in terms of satisfied. Insofar as direction issued by the High Court with respect to pension scheme is concerned in absence of any scheme ought not to have been, could not have been granted by the High Court, therefore direction is hereby passed. In view of the above and for the reason stated above, the present appeal succeed in part, direction contains so and so. Now paragraph 12, my lord, is the gist of the direction. Matters are remanded to the High Court to consider the grievance on behalf of the original litigation with respect to non-implementation of Meghalaya Act 1969 and Provident Fund scheme under the aforesaid Act, if any, to what extent it will be open for the original to amend the petition, to which it will be open for the state to file the counter. However, it is specifically made the demands are only to consider implementation of Meghalaya Act and Provident Fund scheme, if any. So the remand, is with respect to implementation of Meghalaya Act and provisions made thereunder. That is the only issue which is before your lordship. Now, if your lordship kindly see your lordship's order of 31st May, because we have resolved this issue to a great extent,
31st
May 2023, after the remand.
Yes.
The state says that a notification has been issued on May 29, 2023 by Education Department in supersession of a previous notification of April 2018. Such notification that all employees of district college should be included in new pension scheme by converting the contributory fund provident fund scheme with effect from April 1, 2021. Accordingly, the employees are required to provide NPS facility, employee billing, each employee will be held responsible. A second more important notification has also been issued on May 29, 2020 pertaining to non-government school and government college employees appointed to sanctioned posts who joined regular service prior to 1st April which says that second notification covers the areas of dispute involving these proceedings. Such copies of notifications have been made over to the prosecution in court today. So what has exactly happened, my lord? After the order of the Honorable Supreme Court, Learned Counsel for the petitioner, my lord, pointed out that these are the shortcomings in implementation of Meghalaya Act. In terms of suggestion, my lord, we issued notification and amended the act. Now the act is being implemented in later stage. Now, after the act is being implemented, my lord, certain steps are required to be taken by the education department, my lord. One step is to create a trust of the representative from the aided colleges and government representative, and that trust will be managed by SBI. SBI has been appointed as nodal officer. So trust deed has also been created, my lord. Trust deed also includes the name of representative of the petitioner, my lord. That trust deed is at the stage of registration, but in principle, my lord, we have agreed to as because once there is an act, we are bound to implement it. There was some confusion in implementation that has been freezed out, ironed out, my lord. Now it is being implemented. We are at the stage of implementation, my lord. So far as dispute pertaining to non-implementation is concerned, that has been resolved between the parties. No. Now this is with regard to writ petition 281 of 2020. There is another writ petition, my lord, which is tagged with this 360. Now in 360, my lord, if you will see the prayer of 360.
That is with regard to the ad hoc teachers.
Yeah, no, in the prayer 360, my lord, there are so many prayers, my lord. If you will see page 24. Page 24 Act of the petition 360. Now, it's direct all the respondents to take immediate steps to comply with 1950 Central Act. First prayer is
Mr. Kumar, Mr. Kumar,
yes.
You were referring earlier to 281.
Yes. 281.
So,
which was
is any decision taken or likely to be taken in 281 connected with this 360?
No, my lord, that is what I am trying to point out. Your lordship has seen Supreme Court orders. Honorable Supreme Court directed that we only issue, if your lordship will see, the direction is also there. At page, your lordship will see direction in paragraph of this writ only, your lordship. Paragraph 12 at page 34. Paragraph 12 of this writ only. The matters are remanded to the High Court. The Lordship got the paragraph 12
Yes.
No, the matters are remanded to the High Court to consider the grievance on behalf of the original petitioner with respect to non-implementation of Meghalaya Act 1969 and provision for the scheme under the aforesaid Act, if any. To that extent, it will be open to original petitioner to amend the writ petition, to which it will be open to state to file the complaint. So the only issue on which the matter has been remanded back to this Honorable Court, my lord, is with regard to implementation of Meghalaya Act 1969 and provision for the scheme under the aforesaid Act. If my friend has some more grievance or some other grievance, my lord, he can issue a fresh writ petition, my lord, because the Honorable Supreme Court has confined the remand to implementation of this Act only. And your lordship kindly see the prayer in that light. I'm not saying, I'm not shutting him out, my lord, but the matter is on remand before your lordship. It is not a fresh writ petition. It is a matter of remand by the Honorable Supreme Court. And my friend has some more grievance or some other grievances. Remedy is available in law to file a fresh, be separated. But in 360, my lord, 360 and 281, these two matters are remanded only on limited issues. If you lord, so my humble prayer is that in line of, and your Lordship kindly see page 24 of this prayer. Page 24. Directing all the respondents to take immediate steps to comply with the provisions of Implied Provident Fund and Miscellaneous Act 1952. Provisions of scheme under the so and so. All in the alternative, my lord, hold that provisions of Meghalaya None Act would also be able to ad hoc granting. So what is being sought from your lordship is direction to implement, to say, declare that Act is also applicable. That is not, Act is also applicable. To ensure that colleges of ad hoc grant in aid college are given their due benefit, including pension and tuition, under the Act. So now the issue is for the lordship's consideration is what my friend is saying, that our petitioner is saying, that 1952 Act is to be implemented. The writ has been remanded by the Honorable Supreme Court. The case has been remanded by the Honorable Supreme Court on the issue of implementation of Meghalaya Act. Only issue, if you lordship, only issue. If the petitioner has some more grievance, whether it should be implemented to ad hoc or non-ad hoc, he should issue a separate petition which will go before learned single judge, and then therefore I will have a remedy to, and I will file counter affidavit. So far, the implementation of 1969 Act, we have issued notification, my lord, and we have implemented the Act. To that extent, my lord, I can file a short affidavit showing that we have implemented. So the issue to that extent will get settled. I can place those, we have placed those affidavits across the bar, my lord, because, but I can place it showing that we have implemented, because there were some gaps in implementation, my lord. After having detailed deliberations and meeting, we found out each steps were required to be taken, and I advised, and my friend has also advised, both, and on that the Education Department has acted, and 1969 Act is being implemented in later stage. There are certain steps which are being taken, my lord, to further implement it, but those steps will continue to be taken in due course, and there is no issue on non-implementation as of now, my lord, of 1969.
See, Mr. Kumar,
Yes.
in line with the direction of the Supreme Court,
Yes, sir.
petitioner has filed the amended petition.
Yes, sir.
Have you filed a counter affidavit to that?
Yes, I have filed counter affidavit to 281. In
But not,
281, my lord,
but not 360.
360, my lord, is beyond the remand order. 360 prayer is beyond the remand order. That is my primary objection. That is my primary objection. And that is why, your lordship, we have taken a step to implement 281, and 360 is beyond the remand order. That is my humble suggestion.
Let us look into the Supreme Court order.
Yes, your lordship. And you see, in this
Page 20.
page 29 only, your lord. Page 29 of this 360 only. Your lordship, see paragraph 1.
Just where's the reference to? Yes. See, paragraph 1.
Yes,
Reference has been made to both cases.
Yes.
Yes, your lordship. And then after making the reference, my lord, what is the conclusion, your lordship? Will see at paragraph first, their admission at paragraph 8. Page 33. Learned counsel for appearing on behalf of the original writ petitioners has also conceded that writ petition before the High Court and the grievance on behalf of the original writ petition be confined to non-implementation of provision of Assam Act adopted by State of Meghalaya by enacting Meghalaya Act 1969. He does not press for any other relief, including implementation of contributory fund scheme incorporated in Assam Aided College Rules 1960. Now this is his concession before the Honorable Court. Now kindly see the direction, paragraph 1. And paragraph 9 also, the lordship. In view of the above, there is no clarity at all in specific findings
See,
given by the High Court.
Mr. Kumar, see, What is the language of paragraph 12? It says the matters are remanded. It speaks in the plural.
Yes, both the matters have been remanded for implementation of 1969 Act.
Yes.
Kindly see, with respect to non-implementation of Meghalaya Act, with respect fund scheme, if any, to that extent, without kindly see paragraph 35 first line, it will be open for the original petition to amend the petition, to which it will be open to state to file. So to that extent,
of course.
only the prayer,
Yes.
and kindly see the prayer is going beyond that.
Anyway, that is for you to counter. You have not filed a counter affidavit here.
I will file, I will place that. I will place that aspect. I will place that aspect.
Do we take up these matters together, or should we?
The ultimate,
divided.
if I just, what has happened is there is a Provident Fund Act, Meghalaya called Provident Fund Act. That act provided that there should be a contributory provident fund for all the teachers working in the deficit colleges. Now the deficit teachers were now bifurcated. We are bifurcating them into two parts. One where the entire salary comes from the government, and in the other there is a portion paid by the government. Both fall under the deficit scheme. Both are deficit teachers. One is the deficit grantee need, and one is the ad hoc grantee need. The act, the Provident Act, had to be applied to both the teachers. Now the act where we had suggested that they were not implementing the act, some certain things were there had to be one board of trustees. There had to be an agreement with a nationalized bank to hold a contributory fund, and thereafter people contribute and they get whatever benefits come out of the act. As of date, although the board of trustees have been notified, not one meeting. If Lordship would have the last order before this Honorable Court, there has been no meeting held by this board till date.
But I think the last order speaks about suggestions from your side.
My Lord, we gave the suggestions. It stands on that stage only. We do not know whether they have been accepted.
So let us proceed from there.
My Lord, yes. Now, all the
have you given your suggestions?
Yes. On the court itself that day we have given the suggestions.
You have received, Mr. Kumar?
Yes.
We will look into the suggestion.
The only thing that is now required to be done, my Lord, in my humble submission is register the board first with the societies, register of societies, so that the board can function initially. The second is the agreement with the bank. That is what I'm submitting for the deficit grantee need. Now, my Lord, for the ad hoc grantee need, what has happened is they were not even brought under the CPF. They are not under any other provident fund scheme. In that situation, it is the EPF Act which comes into play along with a heavy penalty not only on the colleges but also on the government. So, my Lord, what we had suggested is, if Lordship would have the prayer which I have made, is either implement the EPF, giving me some sort of provision, or
even for that matter,
my Lord,
now the state says that they are yet to file the counter.
Counter affidavit, yes.
We are yet to look into the matter in its
Let them file a counter affidavit in 360 of 2017.
As far as 281 is concerned.
And 281, my Lord, what was there in the last order, if Lordship would kindly go through, this Honorable Court had expected them to get the registration done and the agreement made. All the later smaller modalities can be detailed out as suggested by the learned AG, my Lord. But the first official thing that needs to be done to bring them into existence is the registration and the agreement. Without this, nothing can happen because the bank has to bring in the money. So let them take some time, my Lord. Let them get it registered and the agreement executed. Perhaps 281 would.
If I may submit, what my friend is saying is right to that extent, because board of trustees have been constituted, because meeting was held with the representative of petitioners with the education department. A trust deed has been formed also with their suggestion, and the education department has taken forward, because for implementing 1969 Act, which is adopted by Meghalaya, we have taken steps. Now the trust deed is, so there are certain steps A, B, C, F, numerous steps. Now the issue we are having consensus, or we have agreed that if we have to implement the Act, these steps are required to be taken. So first requirement was, my Lord, notification, which we have notified that now the trust has been notified.
Where is it? Where's that notification? Where's the notification?
And that
That
notification may not
notification, Lordship would find.
be reflected in the order. My friend can see that.
Just a minute.
This is dated.
Notification.
If your lordship will see 5th July 2023 letter which I placed before your lordship. 5th July. 5th July 2023. My colleague can give the copy also to the honorable judge.
Do you have this one? Do you have this one?
I have 29
This
days.
is the thing. You've got how many sets? No, I think these are two different things. Kindly look at it. These are two different things. So you need one more set.
It contains minutes of the meeting dated 30th June 2023.
30th of June.
30th June.
30th June 2023.
16th March.
What I will do, my lord, I will play because it was placed one by one.
You should have,
Let me-
Mr. Kumar, what you could have done, you should have prepared a report and file it.
Yes. If the matter is taken up after 2 weeks, my lord, I'll also file a compilation of all the notifications and the proposals done till now. And perhaps Learned Regio also can have his team prepare that report. I'll have a compilation made. Let the matter come up after 2 weeks. We'll see, my lord, what development has been made for the registration of the trust and the execution of the agreement. That would solve 90% of the problem in 281.
And in the meantime, in repetition, my lord, I am praying that to 360, my lord, I have been raising plenty of
Yes.
You can do that.
So we'll have a chance to reply to that.
I think in 281 you have reached a certain stage of consensus.
So, my lord,
So
yes.
perhaps
What
you
they are
just
trying
have
to
to
do?
go forward.
Yes, my lord. Two official work now remains to be done. Those two done. Thereafter, the modalities would be with the government to.
Two matters to be taken up together, should be segregated.
Yes.
Should it be segregated at 360 and 280? Or should be taken up together?
I think it should
My
be
lord,
segregated
my lord,
because then the issue
ultimately,
becomes
if the government, if the provident fund scheme is to be applied to the teachers, then 360 teachers would also be included in that scheme.
that would come
That part
later.
remains
That
only.
would come later. You see,
Later.
now,
Lord, it may segregate.
now what happened is, as far as 360 is concerned,
lord.
affidavit is yet to be filed.
So let 360 be
Then
segregated.
your line of argument would be different.
Would do, yes.
281 would be, I think it
281 would
proceed
come
in-
to an
it
end
would-
very
yes, it
soon,
will come in
is
a
what we are
different
doing.
direction then. So we'll segregate. It may be, you see, it may have, emanated out of a common, order of Supreme Court. Okay, we'll not pass the order to detach the matters.
My lord.
Let the affidavit be filed.
Thereafter, we can.
Then
take
you
it.
can.
That would be.
Yes, sir.
Lordship, after the state files affidavit with regard to 360, I'll also on the piece of the state's affidavit, because 360, unless and until they file the affidavit, we are in a confusion state what to file, what to decide.
She sends for the
That is
Provident
up to
Fund,
you.
Employees
That's up to
Provident
you.
Fund.
After the state files.
But Mr. R. Or Mr. R. Melinda, and counsel for the petitioners, for the petitioner association. Also Mr. A. Kumar, landed AG, appearing for the state respondent. And Ms. P. Bhattacharjee, appearing for the respondent number 3. Who else is there? And Miss, I can think so. Yeah. Parties have made separate submission and contention with regard to WPC number 281 of 2017 and also with regard to WPC number 360 of 2017 respectively, which according to the Learned Counsel for the parties may be taken up separately, though the matter are connected with the common order passed by the United Supreme Court in article number 1.
In civil appeal 5778.
Yeah, we'll note down. It's okay, she can note down. We'll note down that number.
Yes, sir.
As far as the issue raised in 281 is concerned, it appears that on the basis of the previous orders passed by this court, steps have been taken by the state respondent, to which the petitioners have also taken part in the process to a certain extent. This pertains to the formation of a trust and the modalities for the same, as far as the welfare of the members of the Petitioners Association are concerned. It is, however, submitted that there are certain more steps to be required to be taken, for which the parties may be allowed to file a report for this court, particularly the state respondent. The petitioner, on the other hand, has also submitted through his counsel that he may be allowed to file compilation of all relevant papers relating to the subject matter, so as to enable this court to pursue the same and peruse the same and to pass necessary orders thereon. As to WPC 360, I full promoter, the learned AJ has submitted that the state respondent may be allowed to file, the state may be allowed to file a counter affidavit which has not been done so.
And I also raised the issue of maintainability in the light of the order of numbers.
You can raise in the learned AG has also submitted that the issue of maintainability may be allowed to be taken up as far as WPC 360 is concerned. Accordingly, at this juncture, as far as 281 is concerned, the parties are allowed to place their point of view on record by filing their respective reports or papers. And as far as 360 is concerned, the state respondent may be is allowed to file the counter affidavit on premium with the parties. This is matter after 2 weeks. 2 weeks.
Yes, sir.
2 weeks. Anything else? Anything else? They will file the report. My brother has just pointed out to that paragraph 5 and 6 of their last order. Just look into it, Mr. Kumar.
Yes, I will take the lordship. We will file appropriate report also in that regard, along with my
IT report to add to the London AG has also submitted that in compliance with this court's order dated 5/10/2023, the state will also file the report in this regard. So 2 weeks then? What 2 weeks? Thank you.
I'm a blessed.
Clause List, item number 3.
Where were we?
My lord, we were in the advertisement, my lord.
Page 42.
Yes, page 42. There is the last order. The previous matter was withdrawn, and thereafter this fresh petition was filed. And the termination order is at the last page, my lord. That is.
So, as far as your prayer for regularization is concerned, you have withdrawn that petition.
Yes, my lord. In the meantime, what has happened? I was totally
Yes, you were terminated.
thrown out
Your
from
service
my
was
service.
terminated.
So therefore, that termination order was to be
Now
challenged.
that has been challenged.
That has been challenged here, my lord. Now, if my lord will come to the petition, my lord, again. Yes. Page number 10, my lord.
Yes.
And if my lord will come to page number 21. This is another advertisement, my lord. That is 13th April 2018.
After your termination?
No, my lord, prior to that. And even this time, by this advertisement, my lord, the post of librarian was advertised, and the petitioner, my lord, she applied for the post.
Yes.
But her candidature was rejected on the ground that she has become overage. Even though the advertisement, my lord, says the people who are already serving in the government department, my lord, the age relaxation is there, my lord. If my lord will see page number 22, my lord.
Have you challenged this advertisement?
It is there, my lord, part of it. My lord, this is this was earlier. I am just trying to point it out, my lord. Serial number 7. 22.
Yes.
Here it says in other side of the column, candidates should not be less than 18 years of age and not more than 27 years. Upper age limit relaxable by 5 years for candidate belonging to SC/ST. No age limit for those who are already in Meghalaya government service, provided they entered service within prescribed age limit. Now here, my lord, the petitioner
Excuse me.
she came by of advertisement after satisfying all the terms and conditions of the advertisement, my lord. And when she was in service, she applied even this time when the post was advertised. However, it was not considered, saying that her age is over. However, the advertisement clearly says about the relaxation of her age because she is already in service. This is one of the point, my lord, which I wanted to point it out, my lord. And as far as my here, my lord, the challenge is only as regard to the last annexure, that is the termination order.
Mr. Sinkon,
Yes.
if you have been appointed, okay, it may be a regular process of, advertisement, written exam, and a personal interview, then eventually, selection and appointment.
Right, my lord.
But you are still appointed under 3F.
Right.
So, would that qualify you as a government servant or
for regularization? Yes.
Not for regularization, but even at that stage.
At that stage for consideration. Yes, my lord. My lord.
To come within this definition of, government service here.
Now, my lord, that is, I'm not onto that advertisement. I just wanted to point it out, my lord. Now,
So you're not pressing on
no, my lord. My lord, if my lord will come to page number 34.
Yes.
Page number 34, my lord, these are office orders whereby employees from different department who were appointed under regulation 3F, their services were regularized. Even the next annexure also, my lord, it is at page number 36.
Okay. All those appointed under 3F were regularized.
Regularized, my lord. Even in page number 39 also, my lord.
Page number
39.
36 also.
36 and again 39, my lord. 39, 40, my lord, these are
fine.
Now, similarly situated people, my lord, here, she was also appointed under regulation 3F and her services could have been regularized. But what has happened, when we came before this court for a direction to the department for regularization of her service, what they have done is they have terminated her service. And therefore, I was compelled to withdraw that case and then file a fresh, my lord, including the termination order for its challenge, my lord. Now, in the meantime, my lord, if my lord will see the last page, that is the termination order, there is one person by the name Rilankimon Khongla. He's also arrayed as a party here, my lord.
Yes. Is he represented?
No, Your Lordship, he has
No,
never.
he never appeared, my
Even
lord.
principal also has not filed any representation. Respondent number 3 and 4 are absent.
Principal means
The principal of the.
it's a government government establishment.
Yes, Your
So you should have been representing him, or are you not?
No, Your Lordship, we are not. Principal, they have their own counsel.
Yeah.
No, yes, already served the copy, my lord.
Notice was served by the petitioner himself.
Nobody appeared,
but nobody appears.
And this order could not have been passed by the
It is
principal.
on
my lord.
record also.
No, because the principal being an
Only
official,
written to
see, the principal being an official of the government, he may have thought that the government would represent him. And if in your counter affidavit you should have presented your viewpoint on his behalf.
Your Lordship, on earlier occasion it was pointed before other Lordship, and it is on record that principal and the respondent number 4, notices were served and they have not entered appearance.
Okay, so
I am appearing on behalf of the two.
Party order was passed against them.
Yes.
My lord, there is no specific order. Probably, my lord, they were in the same thinking that will be represented by the government because they are part of the government.
Exactly.
Because Your Lordship, termination, because when advertisement is second time her appointment was totally temporary, Your Lordship.
No, that is we are not on that.
Yes, Your Lordship. And when advertisement was made, she applied for the same, and with a request letter to the directorate that her age may be condoned, because the petitioner, my learned friend, has filed an additional affidavit wherein she has admitted that, she has stated that she was born in 1978 and age relaxation is only 27 plus 5, where her initial appointment is.
That is okay. See, that may have been admitted by the petitioner, which is also admitted even at this point of time.
Yes.
But the point is, when that relaxation provision is there.
Provision is there, it is written. Those who have appointed within the age limit, but her initial appointment is beyond age limit, Your Lordship, 33
My
years.
lord,
Yes, Your
there is
Lordship,
one
date of birth is
misunderstanding, my
there.
lord.
Date of
One
birth is there.
misunderstanding is that, my lord. Now, it is the advertisement which says till what time that is the cut of
Yes,
year.
Your Lordship.
Now, as per that advertisement, she is within her age limit. Therefore, her appointment was considered, my lord.
32 years, 9 months, more than 2 days less, 33 years.
Have you annexed the initial advertisement?
Yes,
My lord,
yes,
it
yes.
is there, Annexure 1, my lord.
Both the
Annexure 1.
advertisements are there, Your Lordship.
That is says 21/10/2011, page number 14, my lord.
And in the additional affidavit also it is brought.
Page number 14, my lord.
This is under 3F. So where does it say about the age?
Here, my lord, it
Yes,
says
it is in column 15, Your Lordship. It is not column 15.
This is below 15. Age should not be less than 18 and not more than 27 as on 1/9/2011.
Yes, 11.
plus 5 years relaxation.
Plus 5 years. 32 years. But she is born in, as per the affidavit,
Now-
additional affidavit, Your Lordship, she was born on 30th September 1978.
If my lord
So,
will see.
33 years, Your Lordship.
Okay, but that is
So, only on the ground,
2011.
from the date of,
The advertisement on or before 21/10/2011. So she has to be within 32.
yes.
no 32, but just 1978 minus 2011, Your Lordship, it comes total figure 33. And it is government letter. Principal has terminated her.
Miss.
No, my lord. It is 32, my lord. She comes within 32.
No,
32
it is
years.
not, because it is the letter from the government, Your Lordship, that she
Her
is
date of birth has to be
overaged.
collected, has to be counted from her date of birth.
Date of birth.
Yes. It is not the year.
Your Lordship may come to my affidavit in opposition, Your Lordship, wherein it is from the Deputy Secretary to the Government of Meghalaya has said that she had been overaged at the time she entered the service. It is not the principal, neither by the principal, not by my submission, Your Lordship. It is by the Deputy Secretary to the Government of Meghalaya. It is at page 17 of my affidavit in opposition.
Her birth certificate has been taken to into consideration.
That is not disputed, Your Lordship. It might be because it is the government official has written this.
Doesn't matter. You see, government official or not, you have to verify it from the records. What is this? You see, what is the at the time of application, in the application form, all these particulars will be there.
Yes.
You annex, your
Everything is
mark sheet, your
yes, Your Lordship.
qualification certificate, as well as the.
So only issue regarding this point, Your Lordship.
Well, then.
But advertisement was made, interview conducted, and Your Lordship, I annexed that Sri Lanka he was appointed, duly appointed. Because of she has written a letter to the government for condoning her age. She knows very much aware of the my petitioner is very much aware of the
My lord,
thing.
my only submission they have done some mistake while calculating her age, because on 1st of September 2011 she is 32 years plus. It is not 33, my lord. Now
How come 72, 78 to 90, 2011? Only thing my learned friend can produce the birth certificate.
As on 1st September.
Yes.
2011.
Yes.
She is below 32.
She is 32 years. 32 years plus.
32 years plus means what,
Yes.
sir? 33.
Not yet 33.
But 33 was
That is,
32. Cut of date
of
is
course.
32 years, Your Lordship. It is his own admission. My learned friend.
Yes, you see, I think Mrs. Sangor is correct. You see, if you may have reached 32.
Yes.
On a certain date. Let's say on let's say 1/9/2018 or 2011. On this day, you are exactly 32.
Yes.
Exactly 32.
Yes.
But after that, what happened is you are still 32.
Yes, we
Till you reach-
appropriate
till you reach
approximate.
33.
But as per calculation, when something
But
tweak,
sometimes what we do is we take that, when it is 1st September 2011, 32 means we take that as 32.
but this is not the only one ground, Your Lordship. While
No,
she
whatever
was
it is,
passed,
as far as age is concerned, maybe you are
yes,
that calculation.
not only this, Your Lordship. While she was appointed, she was made to sign an agreement. It is on record, Your Lordship, in the affidavit, Your Lordship, that she will not. She will, in clause 7, Your Lordship may kindly have this affidavit. It is in page 12.
Anyway, I'll listen to your
Yes, Your Lordship.
argument. Yeah. But these things have to be taken
Yes,
to
Your Lordship.
account also.
That up to the discretion of the Honorable Court, that age can be condoned
No,
also.
it's not a question of age.
But
It's a
Your
question of
Lordship, let me,
records.
because I am instructed by the official, Your Lordship. It is not by. And her
I think Mr. Sinkon has to produce an authority too,
My lord.
which says that this how age is to be calculated. There must be some,
Right. There must be.
some literature, some
Yes.
documents, some how
And-
age is to be taken into account.
And those were, Your Lordship, my Lord, submission regarding those who were appointed. Those who were appointed prior to 2011, they were appointed because it was cabinet has decided regularize them. That's why. So it has nothing to do with the appointment of the
My lord, even
petitioner.
recently also I can produce, my lord, there are people who have been whose service has been regularized, who were appointed under 3F, and government council is quite aware, most probably.
Yeah, that series of
Yes.
regularization has been
Yes.
has taken place. Anyway, that's
Now, my lord, here the challenge is as regard to the termination order, my lord. That order is wrong because it was not issued by the proper authority. Now, it is not the principal who is authorized to terminate the service of the. Therefore, the order has to be set aside because it is not passed by the person who is authorized to do so, my lord. That is one ground, my lord. Therefore, that order has to, my lord, be set aside. And whereas the service of the petitioner is concerned, my lord, and the appointment of another person that is concerned, that appointment was done, my lord, without following the procedure. There was no written examination.
There is
I have given in my affidavit also, my lord, there was no written examination conducted as in terms of the advertisement. And then
so you have challenged his appointment.
no, it is nothing
I
is
have of
challenged,
course
Your
not
Lord.
challenged, my lord, but I have made him a party here. Yes, but my only challenge is as regard to the termination order, whether the termination order is
Even
sufficient.
advertisement is also not
If
challenged.
you have specifically challenged his appointment,
Of course,
on
my
the
lord.
basis that the procedure was followed was wrong.
No, nothing in the plan, Your
My lord,
Lordship.
it is
Pleadings are there, then of course.
It is the same order, my lord will see, same that last annexure,
Yes.
the termination order, whereby the other person was appointed. Yes.
Sure, yes. But you have
But
now
I have-
submitted that
Your Lordship,
his
I have-
appointment was also
Illegal.
improper or
Yes.
illegal.
I have made my amendments here.
But Your Lordship, I have
Yes.
annexed the appointment letter also notification. It is by the Meghalaya Public Service Commission and all.
That is my limited submission, my lord. No more further submission.
Have you got any authority to support?
My lord, I will try to submit, my lord, by next.
So you'll
Your Lordship,
do it today or next date? Tell me.
next date, Your Lordship. Today not
submit,
possible.
In the meantime, you prepare your written argument,
Written
as
argument,
said, with the authorities,
Yes.
and then
So, Your Lordship, regarding this issue, regarding this date of birth, Your Lordship, so
it is for you to justify that,
Ju-
and for him to
because it is from the government record, Your Lordship, it is very much clear. The Deputy Secretary has might be has gone
it's not
through
that.
some.
See, now we have. I think what has been, if I am made to understand
Yes,
correctly,
sir.
it is only how it is reckoned. You see, whether 32 would means once you reach 32 is 32, or 32 means continuing till you reach 33.
33.
So you see, we'll have to take that together.
Because, Your Lordship, whenever we apply for something, when the cut-off date is 32 or 27, we'll have to be 27.
there was-
Beyond one day also, government, if we apply as a general candidate, Your Lordship, our candidature will not be accepted.
There was a confusion a few, maybe, I think, a few
Even
years,
LIC also, if
few years ago, there was a confusion with regard to the Independence Day. Whether it's 75th or 74th. So
yes, yes, we
that is
also.
because of that,
Yes,
that line of, understanding.
Obliged.
Heard Mr. Enscon, legal counsel for the petitioner. Ms. As per Shaji, Leonard G has appearing for the respondent, state respondent has submitted that she may be allowed to respond to the said submission on the next date. As prayed for, this is matter up to 2 weeks.
Much obliged, Your Lordship. Your Lordship, I beg to, with the permission of the court, my learned friend can submit this, whatever it is, school certificate also, to justify his
That
her
has not been
claim.
done.
School
My lord, I
certificate.
have given my date of birth, my lord.
Date
If
of birth, not it is not, but
That is not-
supported
if
by
it is
documents.
available, my lord, I will.
Is the birth
supply.
certificate that would
Right.
be
Birth certificate, if birth certificate, not the school certificate is enough. Metric admit card, Your
If
Lordship.
available, my lord, will
you do that.
file it along
Yes,
with the written
because she
advance.
is a master degree holder, she
Then
might
that
be.
would not be that would not be recognized.
Yes, Your Lordship. Because from office it is
If you have to do that, then you have to file it by way of a affidavit.
affidavit, yes,
My
Your
lord,
Lord.
by next date, my lord will.
Unnecessary creating confusion, that is the just
And also an explanation as how, again, like I
Has
said,
to be
how the
calculated.
date of birth is to be reckoned, or the age, not the date of birth, rather the age.
Age,
is to be reckoned.
much obliged.
You can do that, and we'll see next day.
Obliged.
Much obliged, Your Lord.
On supplementary cost list 1, item number 1.
Yes, Mr. Panthi, what is
May please, Lordship. Lordship, may kindly come to page 14, my lord.
Yes.
This order dated 4/10/2023 passed by this honorable court, wherein my lord had granted interim protection for 1 month, and my lord, if I may read para 4, he is also directed to report to the district prisons and correctional home on expiry of 1 month's period from today, that is on 5/11/2023, my lord. So, my lord, pursuant to the order passed by this honorable court, my lord, what happened is, this my accused person, my lord, he was undergoing medical treatment, my lord, at Negrims. So, subsequently, my lord, he had gone, he was continuing, and thereafter also, my lord, he had gone to Negrims. And my lord, what had happened, if my lord may kindly come to page 16, my lord.
Yes.
She was asked to come to the hospital, my lord, for further treatment. And my lord, this is the.
Was he hospitalized?
No, not hospitalized, my lord. He's still undergoing medication, my lord. And there is some. He has been advised. He has been advised, my lord, further medications, and also, my lord, to avoid exposed to cold, crowded. My lord, the type copy is at page 17. My lord, may kindly come to the last part. My lord.
Yes.
It says AMO2 Syngrobitin, Focot 200. My lord, this is some medications, my lord, he has been asked to continue for 2 months, my lord. Then thereafter, at the last paragraph, patient is advised to avoid exposure to cool, crowded areas, dust, in order to prevent exhaustions of bronchial asthma. Advised not to do any heavy walks, my lord. So there is, some advice by the doctor. In this view, my lord, I'm seeking some more extension, my lord. And my lord, it's he's having this breathing issue, and in fact, in winters, my lord, he has quite.
If I may be wrong, if I recall correctly, just maybe a few weeks ago, Supreme Court has passed an order with regard to interim bail. Do you recall that order? As far as interim bail is to be.
Interim bail.
There was some order, I don't know whether it's. When I saw that order, I remember this case.
Yeah, my lord.
that interim bail is usually not, not to be passed, if I'm not mistaken.
My lord, we'll try to find out. My lord, in the meantime, if my lord will see the bail application, my lord. Now, this application, I have one strong objection, my lord, as regard to the facts. Now, my lord, as far as case is concerned, no facts has been given here. What was the case, for what he was, the accused person was arrested, and not even copy of the FIR was enclosed here, my lord. And what is the quantity of the drugs, what kind of drugs, my lord. Now, nothing has been mentioned as far as this bail application is concerned. So it is very difficult for anybody to understand.
We have annexed my lord's order, the first order which my lord passed, and it's detailed mentioned in that order, my lord. And my lord, it is well settled that in a bail applications, every details of the events need not to be mentioned.
Yes, my lord, those facts are very much relevant, my lord, for what the accused person was arrested.
That is why we are referring to the order passed by
What is
as far as the
paragraph 2?
It is there, my lord.
Yes, paragraph 2, but it does not mention anything, my lord.
Paragraph 4 also is there, my lord.
What is the quantity?
21B, my lord. It's
that is there, but my lord, at least facts should have been, my lord, put in.
See, the fact that he was arrested in connection with this case has been mentioned.
Sections which has been invoked, my lord, also has been mentioned.
Now, my lord, previously also the bail was already extended, and it is the third time, if I am not wrong.
Yes.
And
It's
it
not
cannot
that-
continue like this, my lord.
It's not that, my lord, at his own whims and fancies, my lord, he is asking for extension. He has gone for some, my lord, medical.
See, Mr. I've considered your papers. This medical opinion does not justify.
It's given by Dr. my lord at Nigrims, not some private doctor, my lord.
Yes, may have been given by any.
If it is,
this is a doctor. You are pressing on this point that the advice is for the patient to avoid exposure to cold, crowded areas. This can be done anywhere.
My lord, kindly see.
We can direct the jail authority to look into this.
My lord, kindly see, my lord, the first part. It says, my lord, some medicines also has been prescribed.
So,
and my lord,
medicine
here,
can
what,
already- can already
here,
be
my
here.
lord, what has happened, my lord? Here it says, exposure to cold, crowded areas, my lord. He's suffering from asthma, my lord. And asthma is, my lord, it's during cold winters and this dusty areas, my lord, it's quite serious, my lord. And this issue, my lord, had kindly recall on 2-3 occasions, my lord, he had some issues at jail. In fact, he was fainted, and regularly he was taken to hospital, my lord. Thereafter, then with my lord intelligence, he was my lord, asked to go for medications, my lord. After interim, my lord, he has started.
He's not even admitted in
referring
the
to
hospital,
doctors.
my lord. He's at home.
It's not. My lord, it's not mandatory that he has to be admitted, my lord. His health condition also has to be seen, my lord. If it was completely, my lord, serious conditions. That's why my lord had passed some intent borders. Thereafter, he started taking care.
The court has passed the interim order only with the to give you an opportunity to get a proper
Yes,
treatment.
lordship. Yes, lordship.
You have done so, and this is the prescription given to you.
Yes, lordship.
And the advice given.
2-3 occasions, my lord.
And in
2-3
one occasion,
occasions.
court has already extended the time. This is the third petition, my lord.
That is why that the order of Supreme Court would be relevant. But Mr. Panthi, I don't think you have a case here.
My lord, may
You go back and spend your time there. If you want to file a regular bail application, you do so.
At least for some time, my lord, may kindly grant, my lord. At least there is some.
This medical opinion is.
My lord, it is given by the government also. My lord, it's not that
Yes,
we
it
have
has
asked
been
for.
given. That's why the court has
My lord, may
considered
kindly
this.
see.
court has
Para
considered
2 it
this.
says where 2 months he has to continue that medicines, my lord. And in fact, the last part, my lord.
You mean to say that he cannot take medicine while in jail?
Earlier also, my lord, may kindly recall.
What you can do is, if you want to do so, I can direct the jail authorities to allow you to bring this medicine, give it to them, and let them,
But conditions, but the conditions will not be as homely as my lord. That may kindly consider. Otherwise,
I don't think
just this time, my lord,
you are involved in a very serious offense.
My lord, already 9 months, my lord.
Doesn't matter. It doesn't matter. Yes, and the case is proceeding.
Yeah, my lord, he has appeared before the court, my lord. It's not that he has delayed the trial, my lord. He has he appeared there, my lord. In fact, the copies also he has received.
No, I don't think you have a case, Mr. But you go back. If you want to file a regular application, do so.
My lord, may kindly consider. At least for this time, my lord, may kindly consider. On the next time, my lord, if
no justification. You see, the court has to act on the basis of
certificate is here, my lord.
The certificate does not justify. There is no advice to say that you are to be confined at home. Nothing.
My lord, the last part, what if I may submit, my lord, kindly just looking at this condition.
That I will give.
Earlier,
if you say so, I will direct the jail authorities to look into this matter to ensure that he is not exposed to cold.
At least some extension may kindly be given, my lord. Then now it's winter, my lord. It's winter.
No justification for this extension.
It's winter, and my lord, if it is exposed to, if the accused person is exposed to winter, my lord, his conditions will be more worsened, my lord. I'm just praying, my lord, may kindly take a lenient view, my lord. If it is not, if it's not, my lord, with regard to some my lord, this breathing issue, I would not have pressed, my lord.
This is taking advantage of the
No, absolutely not, my lord. Absolutely not. Absolutely not, my lord. The previous certificate also, my lord, it was there. Yeah, otherwise, we wouldn't have asked, my lord. At least for this time, my lord, may kindly take a lenient view, my lord. I'm just praying, at least for this time, my lord.
Heard Mr. S. Panthi, Learned Counsel for the petitioner, who has submitted that this application is filed under section 482, read with section 439 CRPC, with a prayer for extension of the interim bail granted to the accused. What's the name of the accused?
Vijay Thapa, my lord.
Vijay Thapa. Under this, the petitioner is the accused?
Yes, lordship.
Granted to the petitioner to allow him to be to go for medical treatment. The Learned Counsel has submitted that in compliance with the said order dated 4/10/2023, passed in which petition?
First order, my lord. 4/9/23, my lord.
Criminal petition number
39. First one, my lord.
Yeah, first one.
First one is bail application number 39.
39, no. This order 4/10/2023.
14 is, my lord. 14 is subsequent order, second time, my lord.
Yeah, no. This page 12 is what?
My lord.
Page 12 they have come twice, my lord, previously. This is the third application, my lord.
Okay, so
earlier occasion it was extended time. This is the first bail application, page number 9, my lord.
$39 was the first.
Yes, lordship.
Then it was extended.
Yes, then the second is 110, my lord.
110.
Yes, lordship.
Yes, so we are referring to this 110.
110, my lord.
Because the earlier one was.
Yes, my lord. But even, my lord, on the order dated 4/9/2023 at para 2, if I may just read, my lord. Mr. N. Sincon, learned government advocate, has produced the latest medical report of the said accused, and on perusal of the same, it is confirmed that the accused person was admitted in civil hospital Shillong on 13/8/2023 and subsequently discharged on 23/8/2023. However, on 1/9/2023, he again complained of cough and mild chest pain, which on being examined, the concerned medical officer has referred to civil hospital. My lord, may kindly see.
Yes, that was at that time, my lord, that was done.
It is okay. He can be referred to hospital again. If
for that reason, my lord,
required, he'll do it.
For that reason, my lord, we had asked for, my lord, some private care, my lord.
410/2023 in criminal petition number 110 of 2023. He had visited the Northeastern Indira Gandhi Regional Institute, Nigrims, and after consultation with the concerned doctor, as an outpatient as an option with the concerned doctor, the doctor has accordingly drawn up a prescription with the relevant medical advice. Copy of the said prescription and advice is filed as Annexure 3 at page 16 of this petition. The Legal Counsel has pointed out that the doctor who has examined the petitioner has advised that he is required to take certain medicine for a period of 2 months, and more importantly, the patient accused petitioner is advised to avoid exposure to cold, crowded areas, dust, in order to prevent exhaustion of bronchial asthma, and also advised not to do heavy work. Stressing on the said medical advice given by the doctor, the Land Council has submitted that the petitioner may be allowed to continue on interim bail so as to ensure that his condition turn for the better. It is prayed that the interim bail granted by the said order dated 4/10/2023 be extended. For how long? You did not give any period.
1 month, no, that was 4/10/2023.
Your prayer doesn't say anything.
My lord,
Your prayer does not say for how long you wanted to for the extension.
at least for a month, my lord. At least for a month. We have sought for further extension, my lord.
Yes, but
Specifically, we have not mentioned, my lord. We have sought for further extension, my lord.
last line only. For a period of 1 month from today. 1 month from 5/11/2023. Mr. Leonard G, appearing for the state respondent, has submitted that the prayer of the petitioner accused is not justified, inasmuch as the same has been made in a routine fashion. Reference was also made to the earlier order passed by this court in BA number 39 of 2023, wherein by the order dated 4/9/2023 this court had allowed the prayer made therein, and interim bail was granted to the petitioner accused. the on prayer made for extension of the said interim bail period, this court, by the relevant order dated 4/10/2023 in criminal petition number 110 of 2023, has also allowed the same. The Learned Counsel, Learned GA, has submitted that at this point of time, on perusal of the said medical report and the opinion given, the prayer of the petitioner accused is not justified, inasmuch as he was inasmuch as following the order dated 4/10/2023, he was never admitted into the hospital, but had visited the hospital under bracket Nigrims as an outpatient. It is therefore prayed that.
My lord, it is outpatient revisit, my lord. Outpatient revisit. It's his outpatient revisit, my lord. Outpatient, my lord, when
every time he goes there as an outpatient. He may have gone 2-3 times. It doesn't matter.
Because here it's mentioned outpatient revisit. That's why. Because the first time when we visit, it's out. They write only outpatient, my lord. When you continue to visit, then they say revisit.
Outpatient from time to time.
Yeah, my lord. And one more thing I would like to correct, my lord. This is the second time we are seeking extension, not the third time, my lord. Second time, my lord, extension, not third time.
First bail was granted.
First time by this court on its own, my lord, had granted interim bail.
Second time, my lord, it was extended, and this is the third application.
This second extension, my lord, not third extension.
Extension may be second,
yes.
Second, but this is the third application.
Yes.
No, excuse me. You're saying that the bail was granted.
Yes,
bail was granted. Interim bail was granted on bail application number 39.
Yes, my lord.
Thereafter, my lord, in criminal petition 110, yes, it was extended for
this
1
second
month.
time, not third time, my lord.
Yes, and this is the third application.
So this is the third application.
Third application.
Application is third, my lord, but extension is second. Second time we are seeking extension, my lord.
Yes.
Yes, second time we are seeking extension, my lord.
Second time you see.
Yes, lordship.
Makes no difference. Yes. First you release.
Yes.
Then you.
Yes, lordship.
You got the first extension. Altogether, it is three
this
times.
honorable court
on three occasions you have been.
Yes, yes, yes. Yes, lordship.
It is therefore prayed that this petition will be dismissed as devoid of merit. This court has given due consideration to the submission made by the parties and has also produced the petition and the said medical advice at Annexure 3. A perusal of the said medical advice would show that the only requirement for the petitioner accused at this point of time is to continue with the treatment and to avoid exposure to cold, crowded area, etc. Needless to say, the nature of the advice would reflect that the condition of the patient / petitioner patient / accused / petitioner is not as serious as it was made out to be, and that he is not required to be hospitalized. Therefore, this court is of the considered opinion that the premium for extension of the interim bail granted is not justified. This petition, being devoid of merit, is hereby rejected. The petitioner, as directed by the order dated 4/10/2023, is to report to the prison's authorities on this date indicated. Petition. However, as has been submitted, this court would direct the prison authorities to ensure that the accused petitioner is not exposed to cold or crowded area or dust, and if the medication is required to be given, it should be done so. The family members of the petitioner are at liberty to hand over the medicine prescribed for the petitioner to the prison authorities. How much would this medicine cost?
No idea, madam.
100, 200?
I don't know, my lord.
I don't think it will be so costly. You have the medicine with you?
My lord?
You have the medicine with you?
Medicines?
Yeah. The medicine that was
Yes. Must be the accused person that he has, my lord. That I'm not aware. But he must have this. Since
yeah, because otherwise you cannot direct the jail authorities to. Only if the jail doctor prescribes.
Yes.
Then. Fine. In view of the above, this petition is hereby disposed of. No cause.
Obliged.
Obliged.